Welcome to The Explainer, where we get our hands dirty and break down complex topics by going directly to the source material itself. Okay, let's just jump right in with a pretty fundamental question about our justice system. We think of court orders as being rock solid, the final word. But what if the very foundation of that order is based on a lie? So today, we're diving into a single legal document that makes a really powerful accusation. It claims a court order from way back in 2012 was basically built on a lie. Using this document's own arguments, we're going to explore the serious legal idea of fraud on the court and see why its author says this isn't just some mistake, but a full-blown attack on the idea of justice itself. So, what exactly is fraud on the court? According to this source, it's not about one person telling a fib to another. Oh no, it's something much deeper, something that corrodes the entire system. The source here defines it as a direct assault on the court's integrity. Think of it this way, it's not just cheating in the game, it's like rigging the entire stadium before the game even starts, so a fair outcome is literally impossible. And this brings us to a core principle that the document really leans on. Fraud acts like a poison. It doesn't just spoil the result, it makes the entire process invalid, right from the very beginning. And that leads us to one of the most dramatic consequences in all of law, the idea of a void judgment. The document really hammers this home. A judgment like this is treated as if it never, ever happened. It isn't just wrong or overturned. In the eyes of the law, it is a complete nothing, a legal ghost. Now, to really get how heavy this is, let's compare a void judgment with a voidable one. A voidable judgment, well, it has a flaw, but it's still legally valid until a court officially cancels it. And you usually have a pretty strict deadline to make that challenge. But a void judgment, which is what the source argues we have here, is treated like a blank piece of paper from day one. It never had any legal power at all. So what does a void order really mean in practice? Well, the document, citing legal history, lays out these key traits. It demands zero respect. It can't be used as a defense or a shield, and, this is huge, it has no statute of limitations. The argument is that it can be challenged anytime, anywhere, forever. Okay, so how does the document actually apply this big concept to a real-world situation? The core of its argument boils down to one critical word: jurisdiction. This is a foundational legal idea, right? For a court in a particular state to have any authority over you, you have to have some level of connection, what they call minimum contacts with that state. A court in Oregon can't just drag you in over a dispute you had in Florida if you've never even set foot in Oregon. So here's the sequence of events the document alleges. First, it claims an attorney told the court her client had no contacts with New Jersey. The goal, supposedly, was to get the court to drop the case for lack of jurisdiction. Now, the document also notes that the attorney later corrected this, saying she had misspoken. But here's the central accusation. The author argues this was no simple mistake. They claim it was a deliberate fraud designed to deny the other party a fair process. But the document doesn't just stop with the fraud allegation. It pivots to another critical issue: the right to speak about it all publicly. The author makes a very deliberate point to certify, which is just a formal way of stating, their belief that several court orders in this case do not actually stop them from speaking out. They're making it clear they believe they are not under a gag order. And to back this up, they point directly to the court records. They highlight a 2015 order, a 2017 order, and even an opinion from the appellate division. The argument is that none of these actually function as gag orders, and that, freedom of speech would make one pretty hard to enforce anyway. And here's where it all ties together. The author links the alleged fraud directly to the public's right to know. The argument is simple. If a court was deceived and there's no valid order to stay silent, then transparency has to win the day. So let's take a step back from this one specific document for a second. Why does this whole concept of fraud on the court even exist? Why does it matter? Well, it's basically the system's emergency brake. It's there to protect the integrity and fairness of the entire judicial process, not just the outcome of one single case. It's a way to stop and completely invalidate a proceeding that has been fundamentally corrupted from the inside. And this leaves us with the central question that these arguments really force us to confront. It's a question that goes right to the very heart of our trust in the justice system itself.